Hello and welcome to Moneylife. This is Sucheta Dalal. This week, I'm going to talk about a very interesting case that affects all of us and that we need to watch. In fact, given the raging controversy over Madhvi Puri pooch and the turmoil at the Securities and Exchange Board of India, this order, issued on 26th August 2024, almost got drowned out. This was a path-breaking order of a bench of the Bombay High Court comprising Justice G.S. Kulkarni and Justice Firdosh B. Poonawalla. What they did was to impose an 80 lakh penalty on SEBI, the Bombay Stock Exchange, and the National Stock Exchange. It is unheard of. Why did they do it? Because of arbitrary blocking or freezing of Demat accounts. The bad news, SEBI rushed off to the Supreme Court, and just yesterday, the Supreme Court quashed the penalty and ordered the case to be reheard by the same bench of the Bombay High Court. This happened on 9 September. Now, while I say it's bad news, all is not lost, okay? Because the Apex Court granted the stay on procedural grounds. What it said was that the High Court had issued what seemed like a final judgment on a matter reserved for interim relief. So it wanted the same bench to rehear the case, give an opportunity to the exchanges and the regulator to be heard, and pass an order again. Why is this so important to us? A detailed reading of the order shows its palpable frustration at the manner in which SEBI, along with depositories and stock exchanges, had given the petitioner, one Dr. Pradeep Mehta, a runaround for 6 years. In fact, it's chilling just to read what he went through, which you find in the judgment. After all that he did not get a substantive hearing or a resolution. And to my mind, although this was an interim order, the order is extremely detailed. It has gone into SEBI's powers, the powers of depositories, the Act, various other acts like the Securities and Contract Regulation Act, which are capital market related statutes. And if you ask me, SEBI would do well to re-examine its actions before the case is heard by the same bench, rather than attempt to justify its rigid circulars and failure to give the petitioner a fair hearing, a show cause notice, or meet the norms of natural justice for 6 continuous years when he kept trying and trying. So let me start with what's the broad issue here. It is whether, to my mind, okay, and why this is important to you and me, whether we are investors or depositors, whether banks, financial regulators, depositories, and DPs can arbitrarily freeze your financial assets, whether it's shares, mutual funds, or bank accounts. Now, very few of us have the money to wage a long legal battle like this petitioner, Dr. Mehta. This case complies to a narrow issue of non-compliance by a listed company. It's a complicated case, but the end issue is the same. Can a regulator just block your account? And in fact, you know that when our accounts are blocked for know your customer updates, sometimes without a notice, sometimes you get to know of it when a check is bounced, doesn't matter what procedures they're supposed to follow. It is far worse than this case. So if there's such a hard-hitting order in this case, then we can actually expect better. And that's why we need to watch this. So let's look at what this case is. It pertains to non-compliance by a listed company. So we are not interested. But have accounts been blocked in the past? Yes. In fact, SEBI had blocked tens of thousands, some would even say lakhs of accounts between 1st July 2023 and May 2024 for failure to link PAN numbers to the Aadhaar number. They said it was in line with the CBDT order. CBDT had changed it. SEBI continued with it. And in doing so, it denied investors the ability to book profits or make more investments in the middle of a raging bull market. So opportunity lost in terms of preventing losses and profits to be made were huge. But nobody is in a position to put that together or file a class action suit, because class actions are so difficult in India, deliberately made difficult by the government. Anti-Aadhaar activists tell me that the accounts remained blocked until SEBI unilaterally revised its circular and lifted the freeze. No explanation. Regulators don't need to explain. As I've told you, banks continue to freeze thousands of accounts, often without warning, for the simple updation of KYC, which may remain unchanged, which may have been unchanged for 20 and 30 years. But because you haven't resubmitted the documents, your hard-earned tax-paid money is just frozen, and you are running around trying to get it sorted. Now let's look at why this case affects us. This is writ petition 1590 of 2021. The saga of Dr. Pradeep Mehta and his son Neil, who filed this writ petition, paints a disturbing picture of regulatory callousness. The case goes back to 1989, when Dr. Mehta subscribed to 2,000 shares of Shrenuj & Company, the diamond company, promoted by his father-in-law. Over the years, with stock splits, maybe another 1,000 shares bought, shares sold, he had about 20,000 shares in 2016, which is less than 0.1% of the paid-up capital of Shrenuj. He had nothing to do with management, was never an advisor, never on the board of directors, did not even know that he has been categorized as a promoter. Shrenuj did well for decades. In 2016, got into financial trouble, did not declare its results to the stock exchange, and was penalized. That is around the time Dr. Mehta's troubles began, because in 2017, he discovered that his Demat account had been frozen. And why? Because he was classified as a promoter of Shrenuj because of the family relationship. Not just that, his ITC shares were also frozen, no explanation. Even worse, his son Neil had his Demats frozen. He was only 7 when Dr. Mehta bought shares in Shrenuj. This now started a bizarre situation where he's going round and round chasing his tail with no sign of justice. So he first approached SEBI. SEBI told him go to the stock exchanges because it's delegated powers to them and they would consider his representation. He then approached SAT. SAT disposed of his appeal and said stock exchanges will hear him, directed the stock exchanges to hear him. The stock exchanges heard him. What did they do? They cited SEBI circulars and standard operating procedures and said, sorry, you're the promoter of this company. Company is suspended. There's nothing we're going to do. He went back to SAT. SAT again said, he tried to say that I have been wrongly classified as a promoter, but no one would listen. The stock exchanges ought to have listened to this, ought to have gone back and said, what do we do in these circumstances? And examined whether he was wrongly classified or not. Instead, everyone just showed him circulars from SEBI, which is God, and standard operating procedures, and sent him on a chase again. Meanwhile, the stock exchanges imposed a hefty fine on Shrenuj and insisted that Dr. Mehta should go and ask the company to comply. Now, on 4th July 2018, Shrenuj was delisted. This meant that Dr. Mehta and his son had lost an opportunity to sell those shares, and they were stuck with dud shares in frozen accounts. They went back to SAT. SAT again directed them to the exchanges. The exchanges again cited the circulars, and this impasse continued. Meanwhile, there was more bad news for him. The broker Action Financial Services, with whom he had a Demat account, went belly up. So when that brokerage shut down, under the process, these Demat accounts should be transferred to the National Securities Depository. But because this account was frozen, it wouldn't be transferred. So he now sends a legal notice to NSDL. Nothing happened. They went back and forth and no answers, no solution. So finally, he files a writ petition in the Bombay High Court asking for a writ of mandamus to declare SEBI's actions to be beyond the powers granted by its statute, or to declare that the regulator had no power to freeze accounts or impose penalties without a proper hearing. The court obviously was quite taken up by this case. A reading of the judgment reveals that SEBI did reply perfunctory responses about its powers to frame regulations and initiate action against listed companies. It also said that these powers were delegated to the exchanges, who again made similar statements before the court. There was no relief even from SAT, which is an appellate body, but yet, after knowing what happened for 6 years, there was a suggestion that he should go back to SAT. Everybody justified their action as being based on circulars which are drafted by SEBI. It was very clear by the manner in which Dr. Mehta was pushed around by all the intermediaries without a hearing that the court was outraged. It said that it was not only painful but extremely shocking that despite the facts and circumstances revealed by the case, SEBI and the exchanges defended their action when the law mandates them to protect investors. All of us forget that is the primary preamble of SEBI, to protect investors and draft regulation to ensure this, not to harass investors. So the court held the drastic action of freezing accounts without even a show cause notice or a hearing was brazenly illegal, unreasonable, and arbitrary. Court's words. And the SEBI Act does not give the regulator any such power. That is music to our ears, isn't it? Now, Dr. Mehta's son's case was considered even more egregious because the boy was 7-year-old when his father invested in Shrenuj, right? The High Court found this a fit case not only to lift the freeze on the Demat accounts of both father and son, but to order SEBI, BSE, and NSE to jointly make a payment of 30 lakhs to Dr. Mehta and 50 lakhs to Neel Mehta. As I write this column, as I've already told you, the Supreme Court has quashed the costs imposed by SEBI on SEBI and the exchanges, and it has asked the court to rehear the case. But given the path-breaking nature of this August order, I think that rehearing should be tracked very closely by all of us as investors and depositors. After all, this is not a singular, unique, amazing case where accounts have been frozen without justification, without notice, and people have been harassed. This is happening routinely to us, and we do not have the means to fight it. In fact, the irreparable damage and anxiety caused by banks freezing customer accounts without notice or warning just for delay in KYC updation runs, like I said, into tens of thousands, maybe lakhs of accounts, and it continues. Doesn't matter how many representations we make to the Reserve Bank of India because they blame the Finance Ministry, talk about the Money Laundering Act, nothing changes. Government investigation agencies have also asked for freezing of accounts, often without following due process. This is the first time that the court has questioned regulatory overreach in this matter and thought it serious enough to impose costs for callous, unlawful, and arbitrary action. So there is hope. We have to watch the case, which is going to get a fresh hearing. It will be critical for us, for lawyers and observers of the legal system, whether the final judgment forces regulators to adopt a more balanced approach and find ways to protect investors, which is their mandate, instead of harassing us with standard rules and circulars. I talk about these things almost every week. Things will not change unless each of you realizes that you have to raise your voice, you have to ask for change. Change does not happen automatically because nobody is interested in the small guy, which is you and me. So spread the word, make people aware not only of their rights, but about how they are being treated so that people feel more empowered to make a noise. And if you like what I'm saying, please subscribe to this channel. Thank you.